Yes, very. What
My
about?
lord, back to mention item number 35, praying for some indulgence, my lord. Can it be listed on 6th of August?
You are holding the post on in charge basis. 35.
Yeah. No, my lord, DPC has been held now, and affidavit I have only received 2 days.
But if DPC held, you have been regularly promoted.
Yes.
Now you want that it should be from that day.
Yeah.
There is a judgment of my Lord Justice Ansari. Marge. Just check up from Arunachal only. I think that will cover. Otherwise, retrospective effect, there is a latest judgment on 24. Today is 24.
Today is
I think
24.
yesterday or day before yesterday, Supreme Court has said now no retrospective effect.
Oh, that is I understand, my lord, but here even the department is also.
Because you are
exactly
now, you were there on in charge basis for a long time, officiating. Maybe that period will have to be. Okay, fine. On the prayer of Mr. D. Pani, learned counsel for the petitioner and not objected to by the learned counsel for the respondents, the matter stands adjourned today. Registry to list this matter again on 6/8/2024.
My lord, I beg to mention item 23 to 34, my lord. I was supposed to receive instruction after the diversion of the forest land, whether the DFO or the DC will have the authority to evict, my lord. Now I have just spoken. In fact, the DFO said there is no diversion also. So I'll have to take proper
If
instruction.
there is no diversion, there is nothing.
Yes, I'll have to take.
See, because this is forest land.
Yes, ma'am.
Why I required you to take that instruction was whether there was a denotification. Denotification, again, there is a process.
Yes, my lord.
If that process is not followed, nothing is there.
Nothing is there. So, my lord, can this be
I'll
taken
be
up?
left with no work to it. Okay. Item number 15 to 20.
23 to
34.
Oh, sorry, 23 to
34.
34. The learned Mr. N. Learned Additional Advocate General submits that he requires further weeks time, or 2 weeks time, to receive complete instructions in the matter. Full stop. Accordingly, he prays that the matter be listed after 2 weeks. The prayer is not objected to Mr. D.K. Dury, learned counsel appearing for the petitioners. Registry to list this matter again after 2 weeks on a date to be fixed by.
Interim is there in all the matters.
Interim orders, if any, shall stand extended. Except Marti Jega, madam.
Yes. Oblige.
Oblige.
I'm sorry, my lord. May I mention item number, my lord, 2. My lord, in this matter, my lord, I may be allowed to take my lord instructions. She is still serving in the other branch, my lord. As I'm told, my lord, whether she wanted to continue or she wanted to, my lord, contest the case, my lord. So therefore, my lord, at least 2 days time may be given, my lord. On Monday, my lord, I'll come with this proper instruction, my lord. Monday, my lord. Just to take
Mr. Katok, learned counsel appearing for the petitioner submits that he be granted 3 days time to receive instructions from the petitioner as to whether the petitioner desires to continue with the present proceedings. Prayer accepted, list this matter again after a week on a date to fix by the registry.
Lordship, I would like to mention item number 7 to 9 on behalf of Additional Senior Advocate Itori Rami, Lordship. He is having some health
7 to
issues.
10.
7 to 9, 10 is the contempt, Lordship.
I will go with that only. Go together.
No, but that contempt may be closed because it has been complied.
7 to 9. On the prayer made on behalf of Mr.
Itori Rami.
I. Riram,
Additional-
who is said to have personal inconvenience, who is not present in the court on account of personal inconvenience, this the prayer is not objected to by the counsel for the petitioners. So, registry according to list this matters again after 2 weeks on a date to be fixed by 10 को separate कर दीजिएगा 7 to 9. 7 to 9 only, ma'am.
Contempt.
I'll take up. I'll take up.
Maybe I beg to mention item number 2, my lord. Matter we adjourn for the day, my lord. 2, my lord.
2 is already adjourned.
I will have the other set, my lord. Because my senior is out of station, my lord.
2 is already
No,
adjourned.
my, sorry, then 3, my lord, sorry.
Sorry, we will not permit. We wanted the instruction, we fixed the matter, we are carrying the file from Guwahati to here. Let the matter be called up.
Little petition lawsuit and it has been allocated before your lawsuit.
Hmm.
And got information.
See, I've gone through it, but
Mine.
the problem is that Friday this court may not be here in the second half. Today and tomorrow and day after, we have fixed up enough matters. So the next time when I come, first item would be your petitions.
There is only
No urgency. What is the big
It's going
urgency?
for this, only for this.
We'll issue, don't worry. I've seen the files also.
Right.
I've gone through the files also. If possible, let me see on Friday.
Mine,
If not, on my next visit. First item will be yours.
mine, obliged.
Okay?
Mine.
The other parts have been cleared, I suppose. So there is nothing pending for the notice part. MIs and all are cleared. So then it's okay.
Lordship, I beg to mention item number 14. That my conducting counsel is out of station. Due to yesterday, one of his relatives expired, so for emergency purpose, he went to his native place. No, sir.
You are
matter-
taking the matter?
So I'm on behalf of this one, Adam Tatak.
Adam Tata.
Yes, Lordship.
Let the matter be called. Let me see. What can we do? You are for the petitioner.
Yeah, for petition.
Let the matter.
For 1 week. No?
Just be here when the matter is called. I'll assure you no adverse orders. If I don't allow the petition, no adverse orders. If I can allow it, there is no problem.
Item number 1.
Still will. Yes.
Lordship, and basically in this writ petition, Lordship, I'm challenging the order passed by the disciplinary authority, Lordship.
Which is the order?
Page 18, Lordship, Annexure 3,
Page 18.
Lordship. Page 18 of my writ petition, Lordship.
But, Mr. Counsel, these matters have traveled through the division bench, single bench, division bench. It has attained finality. It was with regard to your joining.
Joining.
And now you have been, that first part of the order termination, we are not very concerned. But you have been compulsory retired. And that too in the year 2005. We are now 19 years down the lane.
Lordship.
There were proceedings before this court, single bench went against you, writ appeal went against you. The question here is whether you wanted to join as the junior engineer. You did not want to join under a junior engineer. Basically, the case is that.
Yes.
What more can we do for you? And the
And then-
petitioner was appearing in person in all those proceedings earlier.
That
Okay,
is,
tell me if I can work out something for you.
Lordship, here, all the small grievances here is, Lordship, just want to highlight that. Regarding not allowing me to join. But when the department was bifurcated.
But thereafter they gave you letters asking you to come and join. You never responded. It was published in the paper. You did not respond.
And
Unfortunately, I have gone through what to do.
that part only, Lordship. I'll leave it to your Lordship.
Why are you leaving everything to you? You fight out.
Lordship, that's,
I want you to fight.
that only, that is small part only, Lordship, where
Show
I
me,
was not
show
allowed
me,
to
show me.
join, Lordship.
Whether I can work out something, we'll see. You show me.
Lordship, that,
I have made my mind clear, open to you. Now you work out. Try to
Lordship,
convince me.
page 15, Lordship. May
15.
come to page 15.
Okay, let's come to page 15.
My contention is
Page
15, Lordship.
15,
16, Lordship, sorry.
16, okay.
This is the letter issued by executive engineer, Gekku Lordship, when the department was bifurcated. Lordship. Now, some employees were allowed to join in this particular department, where they have not accepted me as an employee of that particular department.
Okay, show me the show cause. First show cause.
So, course, Lordship, we have not annexed. Lordship.
Then how can I understand?
Lordship, since this matter was taken up as petitioner in person initially, so all those documents I have been asking him, Lordship, he could not furnish. I sought all those documents from him, but could not assist me also.
Anything more?
That's all, Lordship. This part only, Lordship.
Had the learned counsel for the petitioner and also Mr. So-and-so. The petitioner, by way of instituting the present proceedings, has presented a challenge to an order dated 19/2/2014, by which on conclusion of the departmental proceedings so initiated against him, the petitioner was imposed with a penalty of compulsory retirement from service with effect from 5/4/2005. Also, a perusal of the materials brought on record would reveal that the petitioner had remained absent from 5/4/2005, and the repeated notices issued to him in this connection for requiring him to rejoin his services were not responded to by the petitioner herein. Also, the petitioner had also approached this court on earlier occasions, instituting proceedings, praying for release of his salaries from April 2005. However, the said proceedings, both by the writ court as well as by the appellate court, were so disposed of, requiring that the same would be so considered in terms of the departmental proceedings stated to have been initiated against the petitioner hearing. The departmental proceeding against the petitioner was so instituted on 28/1/2011. However, in the present proceedings, the show cause memorandum of charge has not been brought on record. Accordingly, this court is handicapped from understanding the nature of charges that was leveled against the petitioner hearing. Also, the only material now available before this court in the present proceedings to consider the grievance of the petitioner is the order of the disciplinary authority dated 19/2/2014. Also, although the learned counsel for the petitioner has submitted that the petitioner was not permitted to join his services, although he had submitted applications in this direction, the stand as reflected in the affidavit filed by the respondent authorities in the matter, however, presents a contrary picture. A perusal of the order dated 19/2/2014 brings to the forefront the fact that there were as many as 4 charges framed against the petitioner in the memorandum of charge dated 28/1/2011. Also, and the same pertains to the unauthorized absence of the petitioner from duties. Also, article of charge number 4 levels an allegation against the petitioner that in pursuance to the directions passed by this court while order dated 12/1/2009 in writ appeal number 1/2008, although the petitioner had submitted a joining report before the jurisdictional executive engineer on 15/1/2009, he had thereafter not reported for duties despite reminders and warning letters. Also, the conduct of the petitioner as evident from the only material before this court, that is the order dated 12/19 to 2014. This entitles the petitioner to be granted any relief in the matter by this court in exercise of its extraordinary jurisdiction under the provisions of Article 226 of the Constitution of India. Accordingly, if the writ petition is found to be devoid of any merit and the order devoid of merit and the order dated 19 to 9/14 under challenge in the present proceedings would not, in the considered opinion of this or considered view of this court, require any interference. Accordingly, the writ petition stands dismissed.
Right.
Item number 3.
Yes, what happened? Where is your officer?
My single white paper exam.
No, we wanted the officer. We can spare Mr. Dole. There is no problem. We wanted the officer to give us the records. And this order was passed on 14/6. Mr. Das is here.
Yes, madam.
Have you informed him?
Yes, madam.
There is no question, my lord. Why? Because my lord will
See,
kindly see.
this matter we had fixed today with a specific purpose. We wanted to examine whether the Union of India had given a tacit approval. That's all. If not, we would have gone to the state respondents. Now, I am here only till Friday. Next, when I come back, I don't know.
Kindly,
This is not done. And we fix this date after consent from all. Lepo. Mr. Das, can't help it. We'll have to give them a date. What to do? I can't proceed in the matter without the compliance of that order.
And my lord will kindly see, they have not even filed the compliance also.
No, no.
My lord, I
wanted them to.
What
bring
is
up-
there, my lord? Kindly see, my lord. They are avoiding it. That is what your lordship has said. I want to
This
see the,
will lead to
my
an
lord,
adverse
my lord will
adverse
kindly see,
influence.
my lord will kindly see board resolution, your lordship want to see it. Where is that board resolution?
I wanted to have because I pointed out on the other day that, see, you have given me these documents, but in the middle, there are these documents sent by the state. You have not brought that on record with your response. Kindly give it in.
And I have noted down, because your lordship, I thought the matter will be taken up. And consent, my lord, being a senior counsel, how can I give a
You
consent?
cannot.
It has been engaged by somebody else, my lord. I cannot give a consent. I
No,
say, you do.
I would
No,
not
what
have
if-
wanted Mr. Dolo here because we could have taken up the matter on a date convenient. But today was fixed specifically for the officer to give me those documents. See,
Board proceeding, I think, if I am not wrong.
No, I wanted, they had given me a compilation. The compilation things are missing, which are there in the writ petition, but
Yes.
they have not brought on record. I wanted them to bring that on record. Because Mr. Das, as I first told you, my only endeavor is to see whether the Union of India had given even a tacit approval. If
Yes.
there is a tacit approval, that is the end of the matter. If we can exclude the Union of India, then we will catch Mr.
Now,
Nawab.
there are two things which now, for the convenience of the court, of a just and proper decision, I have brought certain documents. And I have taken permission because a matter which was pending before Supreme Court, now it has been disposed of.
I have given you
Gita-
I've given you the permission on the
That's
last
why,
occasion.
what we have done, my lord, we made an RTI after that, because we have to go to a proper procedure.
Hmm.
I told my client, file an RTI, get all these documents. Now, after getting reply, we have filed those documents, and we have come to know that there is an order passed by the Supreme Court in respect, similar issues, similar, but the land is different. And in that case also, some sanction was not there. Sanction was not there. Supreme Court said, no, you have to give sanction. Give sanction. Subsequently, they have given sanction. I have brought notice. I know.
Where is Mr. Dole? Is having sick or something?
he's UK, he's coming today.
UK.
So this UK thing, he knew on that day.
He's arriving.
He
Delhi
knew on
today.
that day. He could have just informed the court. We could have fixed this matter on some other day.
No, he arriving Delhi today.
Well, let it be, my lord, our urgency also there.
It is unfortunate that in spite of a specific direction by this court passed on the last date of hearing, that is 14/6/2024, requiring the respondents to bring on record the requisite documents in the form of a compilation, comma, the same has not been so done. Full stop. Mr.
That's it, right.
H.Z. Raman, learned counsel, appearing for Mr. Doloi, learned CGC, appearing for the respondent, Union of India, has prayed that the matter be adjourned on account of absence of Mr. Doloi from the country. Full stop. The said position is the court expresses its displeasure in the matter. However, given the nature of the dispute involved in the present proceeding, the court is not proceeding to draw adverse inference in the matter on account of the failure of the said respondents to place before this court the requisite material. Full stop. Mr. D. Das, learned senior counsel, appearing for the petitioner, assisted by Mr. R.B. Dukan, however, expresses an urgency in the matter. Mr. Nabam, R.S. Nabam, and Mr.
He come to.
T. Kamduk, learned counsels, appearing for the respondents in the state respondents, have also prayed that the matter be expeditiously heard. Give me a date.
Well, no, let it come before the next available bench, which is possible. On
Accordingly,
4th of February, I will not be there
accordingly-
once again.
list
for
this
peop-
matter again.
On, no, my lord, on 7th, because there are matters, my lord. Sir.
But we will
Eight.
take an adverse inference against him.
Mr. I know.
Yesterday, yesterday he was here. Today he is here. Where was he yesterday? So this is something, Mr. Nabam, you will have to investigate through an
It
SIT.
was what I have
Division
been,
bench.
what I have been told, that he was not somebody has engaged him. He said, how can I appear without the instruction of the council? That's the whole problem with him.
I know.
So let it come on 8th, my lord.
Eight,
Eight.
on 8th.
Yes.
Also. Had I made it part earlier? No.
No, I think. Oh, 8. I think nowadays the system is after 1 month automatically it is, I don't know, that's.
Can it be on 5th, madam?
No, cannot be.
That's our urgency. Otherwise, let them pay 90% of the amount. We don't have any objection. Let them pay 80%.
So the matter be not treated as parted. I've just made parted because earlier I written one. So I've just cleared it. Huh? Sorry.
Otherwise, my
All
lord,
the work done, gone down the lane.
my lord, one request is being made. If really they fail to again produce, let them an interim, my application for interim should be taken up. Because they should, my lord, they should make the
I
payment,
would
my
have
lord.
done it, Mr. Das.
My lord,
like
I
this.
have,
I'm
I
not
don't
sa-
know
See, I've
what
done
will
it
be the
because I was not
outcome.
satisfied.
My lord, what will be the outcome? I don't know. This may go against, but I am
Also,
thoroughly prepared in this case.
एक line let you do. The respondents shall invariably comply with the requirements as made of them by this court, widely order dated 14 इनके last order देख लेना 14 है ना 14/6 I suppose last order 14/6/2020.
Because, my lord, the requirement under this, I have gone through it, my lord. And they cannot, my
Anyway,
lord, they
thanks.
cannot revert. They
Thanks
cannot
to
revert.
you, it was a learning experience.
No, mother,
for me.
we also learned and we have to go through a lot of homework. And your lordship has done in all the way I have come and adjournment is solved. That's the way. I told my learned friend, I cannot give a concession from my side because there are instructing counsel.
And
That's what
take
the
it from
problem.
me, he will never give you a concept. But when it's the other way around, he will take a concept.
It was also a pleasure before the court in this matter, madam. Honestly, I am telling you. Because we have to go through a lot of homeworks for that. Power of attorney, your lordship has catched of power of attorney. That we have to go through that hurdle. I am deeply of this.
A learning experience, Mr. Das.
Yes.
I think number 4.
And this, my lord, power of attorney, that point has been given up, has
That
been
they
given
have
up.
given up. You,
Yeah,
if
that's
they,
all.
if there is any confusion.
Because I don't know your lordship.
I'll not record because Mr. Dolo is not there because at the last moment he made some submissions.
Yeah.
But if you have any doubt, go through that video.
Yes,
of
that's
that day,
right.
it is very clear.
And
Because that is a record of
I
the
just,
court.
yes.
That is a record of the court. You
Yeah.
can always refer to that.
Deeply.
Yes. What is your submission?
Yeah, my lord, I have been imposed penalty under CCSC rules, final penalty, my lord. And I've been directed, recover, loss amount is to be recovered from me.
No penalty, only the loss is directed to be.
Yes, yes. My lord, what happened here? I was on deputations in the Departmental.
You have got the inquiry report now.
Now, yes.
What do you have to submit on that?
Like inquiry reports, my lord, there is nothing, they have not even recorded the witnesses, my lord.
One.
And my lord,
Another point is there.
yes, my lord.
Hit that.
And my lord, co-delinquents, who was the main delinquents, whose duty was to,
He was not examined.
he was not examined. And
Yes, Mr. Tapin. You have referred to the inquiry, single man inquiry report.
Correct.
You have not brought him on record.
Yes, correct, Lordship. But here, if Lordship see the page 85, Lordship. Is statement of the Lordship petitioner was taken, Lordship.
Only, can you convict him on his own statement?
If,
Can you convict him? If that is this law, show me.
if the facts is,
It's for you to establish, because you have gone to record documents. You have taken on record documents.
correct, Lordship.
But those documents were never proved in the inquiry.
That's correct, Lordship.
Proof sing negi.
Here, Lordship, his conduct has been admitted, Lordship. In his
Conduct-
statement,
No, no.
it has been admitted. This,
Mr.
Lordship,
Tapin,
Lordship.
the act on his part of going to the bank along with that man admitted. But he had a mens rea for misappropriating that matter, money in this manner, not appropriate. You come to the charge. Yes. That is at page 55.
yes, ma'am.
You come to page 55, the last line of article of charge number 1. Thus, he failed to maintain absolute integrity. So it goes beyond his going to the bank. Now you come to the next charge. And after taking lunch in a hotel, page 56, 1, 2, 3, 4, 5, 6, 7, 8, 8 lines from above article of charge number 3. So and so, and a pre-planned manner or a plot hatched by so and so, therefore so and so, gross misconduct, right? So you have said that that whole thing was hatched by him, right? Now you come further.
Lordship, see the charge number 2, Lordship, article 2. Lordship. In the next page, Lordship, just about the Lordship, article 3, Lordship. He went to SBI Bank, branch, Itanagar, received the big envelope containing government money and kept the same in his private car, unattended, which was parked at the roadside near the SBI Bank.
No, I'm not on that. Just go there. After taking lunch and left for taking lunch in a hotel, which is indicative of serious negligence, dereliction, or a pre-planned misconduct or plot hatched by so and so. Where is evidence of this?
Sir, we remove the pre-plan or no?
No.
Even if
cannot.
pre-plan is removed also, Lordship. Race
cannot.
conduct,
Because
race conduct.
That's
Lordship.
why I wanted this inquiry report. Nothing is there. And see, you come to the inquiry report. I'll show you. Come to the inquiry report. The officer has referred to just out. Come to the internal page 5. Now, to prove that article of charge number 2,
Close.
you have relied on this page 5, 1, 2, third paragraph from bottom. Page 5, internal 5, down 5, down 5.
Close.
The one-man inquiry report submitted by so-and-so, Deputy Secretary so-and-so, inquiry officer was also examined. The report submitted by so-and-so mentions that contradictory statement and clandestine activity of so-and-so is doubtful and seems to be intentional and free, but he was never examined.
Close. So, but this pre-plan is concerned also. Here, Lordship, it is a matter of the criminal proceeding also. We are not on.
Criminal case is closed.
It has been closed,
No,
Lordship.
no, it's-
Therefore, his conduct, Lordship,
Hmm.
which amounts to unbecoming of the government servant, Lordship. That
that-
part only is a concern. Otherwise, pre-plan is, even if it's there also, Lordship, it will come under the criminal jurisdiction, Lordship. Kindly, Lordship, turn to Lordship.
Now you come to the conclusions
Uh,
at page 13.
Lordship, before, Lordship, can you see page 7? Internal, no, page 7, Lordship.
Okay.
Here the questioners are here, Lordship.
That I'm not there. Come to page 13. This is the final conclusion.
Lordship.
Come to clause 7.
Correct.
Receipt so-and-so creates room for malafide intent, undoubtedly creates room for malafide intention of so-and-so. Now, from where do you get this? Because that theft, if it is a simple theft,
Lordship.
then he is not responsible. If you have to make him responsible, you will have to show that he did it deliberately. Otherwise, you let the other man go.
Only,
And your assistant director, who was supposed to be the custodian of house, you have also not even brought him here. Anything more? जाने दो. Anything more?
No.
कल लगा दीजिए. I'll pass the order tomorrow. Dispose of. कल.
All right.
You will get it by Friday.
All right.
Because today I have slated something, so maybe I'll not get time. Dispose of?
No.
None. We'll only say that nothing was there. I'll apply Rup Singh Negi, saying that the materials or the evidences were not proved. So basing on that, the conclusions are not on based on proved evidences, and accordingly the penalty to nahi hai, recovery is set aside. Right? Whatever you have recovered from him, give it back.
Item number 5.
Yes, today Ramu Valley is chasing us from division bench to the single bench. Now you have moved a contempt.
Yes.
Why should I entertain this repetition?
For that, the respondents are not holding DPC in spite of direction from.
That is why you are there. That is why that proceeding contempt you have.
No,
we have issued
contempt,
notice.
contempt is something else, below. Well, kindly dispose of the direction to them to conduct DPC with relevant rules and the order pass in the IA, below. I think you'll under additional.
Where is their IA order?
IA order, page 24.
Okay, yeah, that order. Now, why is that selection not being done?
My lord, his representation along with the relevant notification for DPC that may be directed to be disposed of. Well, DPC should be held, my lord.
Now, no more release is pending. The main read petition, where the interim order was granted, that has been withdrawn, below. So there is no bar for them to conduct DPC, below.
Which was that 374,
Yes, below.
wherein that order of IA is there.
Yeah.
That is gone now. If that repetition is gone, this IA is also gone.
No, They
How
have,
can this
No.
order survive?
no, no, below the, the withdrawal took place after passing of the order in the IA.
Fine, fine. But along with that, every interim order that this is an interim order only. It
And
also
that-
goes,
Of course, doctrine of merger.
oh, then,
Well, my lord, kindly direct them to hold DPC in terms of leave and rule.
but Mr. T.T. Tara, learned counsel for the petition, and also Mr. N. Ratan, learned additional advocate general appearing for the state respondents. The petitioner in the present proceedings has prayed for a direction upon the respondent authorities to convene the meeting of the Departmental Promotion Committee for consideration of cases of all eligible executive engineers to the vacant post as figuring in the cadre of superintending engineer in the Department of Urban Development, Roman and Housing, Government of Arunachal Pradesh. A perusal of the pleadings as a perusal of the contentions as raised in the writ petition would reveal that there are vacant posts available in the cadre of superintending engineer.
4 vacant posts.
4 vacant posts available in the cadre of, there are vacant posts available
Yes,
in
yes,
the
madam,
cadre of superintending engineer. And the said posts have been lying vacant since the last few years. Last few years? Lying vacant since when?
5 years.
Last few years. However, the respondent authorities have not taken the requisite steps for convening the meeting of the Departmental Promotion Committee as conceptualized under the provision rules. What is the name of the rules?
Below that office memorandum is there at page 34.
No, there is no rule governing your.
Governing field
Give
309.
me that 309 rule.
2014
Governing the dash rules. दे देगा आपको.
common recruitment rules.
I'll just give that. Full stop. The petitioner, Mr. Ratan, learned counsel for the additional advocate submits that the Departmental Promotion Committee meeting should not be held on account of the fact that there were proceedings pending in this connection, right? Proceedings pending in this connection before this court. Full stop. To this, Mr. T.T. Tara, learned counsel for the applicant, has submitted that the writ petition as pending, the writ petition being WPC number 374 bracketed AP/2023 that was so pending has since been withdrawn by the petitioners therein, and there is no legal bar for the respondent authorities to proceed to hold the meeting of the Departmental Promotion Committee, convene the meeting of the Departmental Promotion Committee for consideration of the cases of the eligible executive engineers for promotion to the cadre of superintending engineer. Also, the above being the facts, so facts involved in the present proceeding, this court is of the considered view that the present petition need not be detained further, and the same can be so closed by directing the respondent authorities, more particularly the commissioner, bracketed urban development, no, commissioner, urban development, government of Arunachal Pradesh, to immediately take on record the representation dated 14/3/2024 as submitted, as preferred by the petitioner hearing, and thereafter on consideration of the contentions therein to dispose of the same by directing for convening of the Departmental Promotion Committee meeting within a period, within a suitable period of, within a period of 1 month from the date of a receipt of a certified copy of this order. Full stop. The Commissioner, Urban Development, Government of Arunachal Pradesh, while proceeding to consider the contentions made in the representation as preferred in the matter by the petitioner, shall also, while proceeding to convene the meeting of the Departmental Promotion Committee, keep in view the provisions as existing in the said rules of so and so dash rules of so and so also. The With the above observations and direction, the writ petition stands disposed of.
Much obliged.
Obliged.
We will forward.
Very good, very good.
Item number 6.
May I announce it? Lordship, non-payment of lordship, pension lordship, to the petition lordship. In this case, lordship,
Now, tell me one thing, Mr. Premier. Mr. Nawam, one assistance.
Yes, ma'am.
In this state, say a person retires,
I'm sorry, my lord.
person retires,
Retires, ma'am.
his pension for some reason is not being processed, delayed. Don't you have a concept of giving him provisional pension?
My lord, if I correctly remember, pension is the hard earning of any employee.
I know that, but
That cannot be, my lord, stopped without due process. of
no,
law.
let's say for some reason,
My lord, for some reason, my lord.
recovery, something, it's delayed. Can't that person be given a
At least half
provisional pension?
provisional pension. my
Provisional
lord.
pension can be 100%, but that has to be given by the department. It will be in the account of debit. Once the final PPA is issued, this amount will be debited.
Debited, right, my lord. My lord,
I think it's high time because I've been seeing matters like this. Pensions are not being processed. Maybe everybody may not require a pension, but there would be maximum who would require a pension.
my lord, I don't know, will be not requiring pension, my lord. It's a hard earning, my lord.
Maximum would be required.
In this case, my lord, I am informed, my lord, provision pension was granted to him.
Granted.
Granted.
Earlier, my lord, earlier, what? Yes, my lord, granted my provision. Per 6 months, I informed my
No,
lord.
no, that has to be continued till.
Yes, my lord, that should be my lord.
Can you get me that details so that we can pass an order? That in such circumstances, you will continue to pay him provisional pension till the final pension is
My lord.
regularized. That will help people.
Right.
And that will not cause any loss to you also because moment the final pension is done, it will be adjusted
If tomorrow list time, I can.
tomorrow. We'll have it.
Yeah,
Let's say if we pass an order, we'll pass an order to that extent.
much obliged.
As prayed for by the learned council parties, list again tomorrow.
Item number 10.
Well, this may be closed in view of notice issued by the contender at page 15. They have withdrawn the surplus of their affidavit in opposition.
Page
Page 15, the SP has recalled the eviction notice.
of the reply.
Yes. We'll go back home after this matter.
Hmm?
We'll go back home and enjoy the day.
That is the beauty of that side. I used to boast about it. And I used to tell some quotes also.
I'm tempting lordship.
I'm getting it back. Where is that? Where is that affidavit?
15, my lord, 1-5.
Of the writ petition?
No, my lord,
Affidavit,
affidavit.
19th.
Affidavit, okay. 1-5.
1-5.
This is a contempt petition.
Contempt petition.
Heard Mr. T.T. Tara, learned counsel for the petitioner, and also heard Mr. O. Para, learned counsel appearing for the respondents. Mr. Tara, on instructions, have submitted that the order violation of which has been complained of in the present proceeding, has since been complied with by the respondent authorities, and accordingly, there is no willful and or deliberate violation of the directions passed by this court. Full stop. In view of the above position, the contempt petition stands closed.
Much obliged.
Item number 11. So, my lord,
At the last occasion, my direction was made to the department concerned to produce that whether the
You
relevant.
have any scheme? Have you seen the last order? Oh, this was by Mr. Kato. Kato was
Yes.
up. Yes, Mr. Kato. Yes. Sorry, Chakra person, you are giving him 1.5 lakh. What is this? You don't have any scheme.
My lord, as per the schemes, my lord, we have already
See, the
paid.
states are giving 50 lakhs. Why is the union not giving an equivalent amount?
My lord, that is the ceiling limit, my lord, which prescribed by the, my lord.
But where is that scheme of yours? In the writ petition, it's not there.
My lord.
Because he has, maybe, but we know it. We have seen it. So we want you to help us in this. If there is something due, we want to give it to you.
My lord, basically, the payment has to be made from the state government
No.
side, my lord.
No,
Our part is already paid, my lord.
you have no
No.
grievance against the state government, central
No.
government.
No, my lord. Oh, why I'm against the central government.
You are against the
Union
central
government.
government.
Yes, my lord.
You want the relief from the central
My
government.
lord.
Show me how.
Because, my lord, the so far state government is concerned, my lord, the deputy commissioner has already recommended my case, And-
Mr. Modi,
my lord.
the recommendation of the deputy commissioner will conclude in Itanagar. It will not go to Delhi. So from Delhi, do you want any relief?
My lord, yes, from the, my lord, respondent number 3, my lord.
Respondent number 3. Commanding officer, 3rd Battalion, that is the government of India. Again, now show me what is that scheme for payment? Because they have paid you 1.5 lakh rupees at that point of time.
My lord, that was not on the ex-gratia, my lord, that was the insured, that was the group insured amount.
So show me
Insured amount
the
by
scheme
the
of the
us.
government of India governing the payment of
Right.
ex gratia.
So, my lord, this particular, this scheme was, my lord, sought from the government of the union. And at the same time, my lord,
Now you
right
catch hold
now, I
of
don't
Mr.
have,
Kato.
but
Catch hold of Mr. Kato nicely. He's not giving this scheme. I can't go that side now. You will have to catch him.
and I have, my lord, so from my
Mr.
lord,
Kato,
My lord.
get that scheme prevalent at that relevant point of time. Because we don't find this state to be in any manner
My lord, more-
liable
more-
to pay.
As per the notification, my lord, annexed by the petitioner is at page number 41.
Hmm.
Basically, this is the state government scheme, my lord.
The state government scheme will not cover him because that death occasion in Punjab.
Yes.
And the state government had not deputed him there.
Right.
So it's you. And see, his statement is that the money 1.5 lakh that was given was the group insurance scheme. Have you seen the last order? 18/7/2024.
I'm sorry, my lord.
You were not there, your junior was there. Mr. Kato, learn it. We'll see, mister. We can help you out somewhere. Mr. Kato, learn it. DYSGI prays that he be given further 2 weeks' time to bring on record the policy of the government of India in connection with payment of ex gratia amount to members of the armed forces, who were killed, permanently disabled or grievously, last order they claim. So and so, full stop. Prayer accepted, raised it to list this matter again on Well, 8/2024. See, Mr. Kato,
My lord.
a person has given up his life for the country. Maximum what we can do for the family, we will have to do. So why are you pulling back that scheme? His petition could have been structured better, but the issue is there. The prayer is there. So we will require him. Kindly produce.
Develop.
Mr. Modi, wait, let's see what is there. And Mr. Modi, you can file an additional affidavit to bring on record matter that was not the ex gratia paid, but the group insurance.
Another,
So there is a confusion there.
another thing, my lord. Union of India is not a party, my lord. The commanding officer is not going to, my lord.
We
ultimately-
will not go into technicalities in such matters. At
Otherwise,
least
my lord, the
where
payment
I
is-
have to go into technicalities, I'll go. Land acquisition matter and all, we'll go, but not in this matters. Never.
However, my lord, the payment has to be made by the Union of India, not from the commanding officer.
We will direct the Union of India. You tell us the authority, we will tell him. But first give that scheme to us. And don't take any, if I'm not here also, any other bench, please don't take technical points when it comes to martyrs who had died for the country. Please don't do that.
Item number 12.
Lordship, yes, contended earlier, Lordship. This matter is covered case actually, Lordship. Lordship, may
Cardamom.
Cardamom, Lordship. Lordship may kindly come to this honorable court.
Yes, my
order
lord, in
dated-
two cases, my lord, it has been decided, my lord. We have to honestly admit, my lord, clearly admit.
You admit to that.
Yes, my lord.
The author was here, Mr. Rabha is gone. Mr. Rabha was the counsel, he was here before the Lordship.
Yes, he was considering those matters, my lord.
So we'll have to follow which one, writ appeal 24 or writ appeal?
Lordship, we can, since it is the same stretch, Lordship, we can follow. Writ appeal 40, Lordship,
40.
40. Because this is covering writ appeal 24 also, Lordship. Earlier, same issue was brought in writ appeal 24 of 22, Lordship.
Also heard Mr. So-and-so learned counsel for the petitioner, also heard Mr. Kato learned deputy SGI for the respondents number.
5 minutes.
Hmm?
Respondent number 5. Commanding officer.
Okay. Who will be appearing for the chief secretary?
I am for
Mr.
respondent
Tapin.
number 2, my lord.
Mr. Tapin, learned senior government advocate, appears for respondent number 1, 3 and 4. Mr. Contempt, learned standing counsel.
Yes, my lord.
Respondent number 2, and Mr. Kato, M. Kato, learned deputy SGI for respondent number 5. The grievance raised in the present proceedings by the petitioner pertains to the manner in which the compensation for the land, more particularly the compensation for compensation as determined for the horticulture crops standing, horticulture crops, cardamom standing on the land of the petitioner was so computed. Also, the learned counsel for the petitioner as well as the learned counsel for the respondents are at edit that the issue arising in the present proceedings is covered by the decision of this court in the case of state of the decision of this court in the case of state of Arunachal Pradesh versus and 2 others versus Mankaso Tafla and 47 others, bracket mein, order dated, judgment and order dated 4/1/2023 in writ appeal number 24/2022. Also, the conclusions as drawn by this court.
Lordship, one more is there, Lordship. Writ appeal 40 of 2022, Lordship. That may also be.
No, I'll go by 40 then. 40 is the latest. We'll go by 40. Or you want me to go by 24? We'll go by
Lordship,
1.
we can go because this 40, 24 is covered in 40.
Okay, then we'll go by 40. 40 of ये लिखो तुम्हारा नाम है State of AP and others versus Topenso Tega and 123 others. Box follow. Judgment and order dated 6/12/2023 in writ appeal number 40/2022. Also, the conclusions drawn by the honorable court by the division bench of this court in this said case being relevant is extracted here in below. $16. Huh? No. Here also joint survey, then it was reduced.
Reduced.
Okay.
That was set
This
aside.
is from which street? Kapoor to Changlong Circle, Anjaw.
Anjao, same.
Same. Then para 3 se mado. 3, 4, 5. Then dot, then 8. Dot, then 10. 11. 12, 13. 14. 15, 16. 16th, huh? Writ appeal 40 ka, 16. So, in view of the above, the present, the directions as passed by this court, white judgment and order dated 6/12/2023 in writ appeal number 40/2022 and extracted herein above shall also cover the issues arising in the present proceedings. Full stop. Consequently, the petitioners would now be required. This is against writ petition 320, right?
Yes, Lordship. 40 is against 320, Lordship.
Consequently, the petitioners herein are directed to be authorize the due compensation. Does this impugned bill of 14/8/2020 also include your amount?
No, Lordship. That is
Accordingly, the respondent authorities are directed to authorize to the petitioners hearing their due compensation for the cardamom crops as standing on their respective lands in accordance with the directions passed by this court in writ petition the directions passed by this court while order dated 8/9/2022 in WPC number 320/2021 and upheld by this court while judgment and order dated 6/12/2023 in writ appeal number 40/2022. With the above observations and directions, the writ petition stand disposed of. Whatever is there, that will be covered in your case.
Lordship, more specifically, Lordship, here the amount that was payable to me, Lordship. Lordship may kindly come to.
No, that decision is already there. So whatever has the court has also decided, the first round of whatever it's there, that you will get it. That you will get it here also. Same decision.
Oh, all right, Lordship.
Whatever decision is there, that will be covering your case also.
All
So it's like that your case is also there. Why should I go and pass a fresh order? Covered. See, something is there, come back with a review. इसको भी अंदर रुका के
Obliged, Lordship.
समझ गया ना?
13.
Your Lordship, we will be filing our reply.
Will not help. Now tell me, the power of this court in a matter of non-payment of bills.
Yes.
Can this court make an adjudication? No. This court can pay direct for your payment to the extent it is admitted. Your claim is around 35 lakh crores or lakhs something. 35 crores.
Yes, Your Lord.
And they have admitted to 5 lakhs.
5 lakh, that is to be paid by central government.
Now, how can we, in this disputed questions, how can we, you go before the trial court, institute of money suit, get the payment. We can't. Because I cannot make Sri Vidya Thi and all those line of cases. If there is a dispute, then we cannot commit under Article 226.
But Your Lordship, the decision was made without informing
No,
us.
that decision should be here in the affidavit. The affidavit, they have not admitted to you, whereas they have disputed your amount. And they say 5 lakh rupees is receivable by you, which you will have to, which is from again from the central government.
Which is why, Your Lordship, we need time to reply.
No.
to that.
Reply will not develop because that affidavit is already there.
Please an opportunity, Your Lordship.
Opportunity. Okay,
Yes.
tomorrow.
Your Lordship,
Tomorrow.
Your Lordship, August 12th,
You don't want to do it before me.
Your Lordship, the
On the
conducting.
prayer of the learned counsel for the petitioner, raised it, not objected to by the learned counsel appearing for the respondents. Raised it to list this matter again after 2 weeks on a date to be fixed by.
Deeply obliged.
See,
Deeply obliged.
read the law. It's against you. And now by filing a affidavit also, you cannot force this court to make an inquiry because that will require an examination now of evidence, which this court cannot. I can only go by affidavits. If they admit, I will pay you interest also. There is no problem. But admission is not there. See that line of judgments of the Supreme Court. Then make submissions.
Definitely, Your Lordship.
Young
Deeply obliged.
counsel, you should now try to explore, say that why I am wrong. You should come up and argue that, no, sir, you have said this, but this is wrong. This is the law now. Come, I love it.
That's why we have also raised preliminary objection, Parliament.
Young counsel, let him work.
And we will reply to that, their objection.
That you do, but work on that legal point.
Yes,
Don't
Your Lordship.
accept what the court is saying. Fight out
Yes, Your
in a
Lordship.
polite manner.
Deeply obliged.
Yes, what happened? Where you
Sir,
wanted an adjournment?
Lordship, conducting counsel is out of decision.
Who?
Is.
Your Lordship, I have been told that his relative has expired. That's why.
It is submitted that learned, what is his name?
Adam Tatak.
Mr. Learned Counsel, Adam, appearing for the petitioner is in bereavement and accordingly, a prayer has been made for adjournment of the matter. Was a prayer accepted? Raised it to list this matter again after 2 weeks on a date to be fixed by.
Obligation.
Item number 15.
$500 square foot, any way out? Too busy. Now you are one man against the whole town. No, forget it. We are not on that. We are beyond that.
Madam, this land.
This land, if you have something, go before the civil court, establish your right. We'll permit, as I'm discussing. I tried, for the last 2-3 days, I've been pressurizing Ms. Ede to get something. So now this is what has come out.
Initially, they said that I can go the government land.
You don't have a LPC against that land.
Yes. No.
That land is required for public purpose. Proceeding was initiated. You went up on appeal. Then you say you purchased that land, but there is a document brought on record saying that you have sought for 500 square feet for commercial cum residential purpose. Now the Ms. Ede has brought on record that, so we want this for public purpose. So we are not, and there is no alternative land which we can give him. So in such circumstances, if there is any right of yours accruing with regard to that land, go before the civil court.
Madam, this land was never acquired.
Did not be acquired, it's their land. You are the one who is acquiring it now. The reverse acquisition is taking place.
This land is under my possession since 19.
That will not give you any right if that is required for public purpose. That's why I said, if there is something here, some right, I can protect that to the extent by permitting you to go before the civil court within a particular period of time. There is an interim direction here, status quo. I'll maintain that status quo till that time.
If assume that the government that I have purchased, government and illegally, in that case also my lord,
Mr. Modi, all these things before the civil court. I'll protect you. Do one thing, in view of this, you withdraw this to approach them. I'll protect you till, I'll give you a time. Till that time, I'll protect you. I heard Mr. Modi, learned counsel for the petition, Ms. Ete, learned government advocate appearing for the state respondents. Ms. Ete, in terms of the directions passed by this court, where the earlier orders in the present proceedings has received instruction and placed the same before this court. In terms of the instructions received by Ms. Ete, it is seen that the land as occupied by the petitioner herein is required for public purpose, and accordingly, the eviction proceedings against him were so initiated. Also, it is further provided that the eviction proceedings having been so initiated, the application of the petitioner for allotment of the same very land in his name has been rendered infructuous. Also, as regards the query of this court, whether any alternative plot of land can be in and around Pasighat town can be allotted to the petitioner hearing, it has been brought to the record that at present there is no government land available for such private allotment. Also, post with the said position, Mr. Modi, learned counsel for the petitioner submits that he has a right over the plot of land which he has been occupying without any interference from the government authorities since long. And accordingly, he submits that he may be permitted to withdraw the present proceedings and agitate his right, title and interest over the plot of land before the competent court of civil jurisdiction. Also, the said prayer of the petitioner is not objected to by the learned counsel for the respondents. Also, in view of the above, the present petition is dismissed on withdrawal with liberty to the petitioner hearing to approach the court of competent civil court of competent jurisdiction within a period of 1 month from today. Also, till the period of 1 month from today, the interim directions passed by this court, while the order dated 3/2/2023 shall stand extended. Full stop. It is provided that in the event the petitioner fails to institute appropriate proceedings before the court of civil jurisdiction within the period of 1 month so granted, the interim directions so extended by this order shall stand vacated. Also, it is further provided that the interim order would be continuing in the event such proceedings are initiated by the petitioner hearing before the court of civil competent court of civil jurisdiction, and it would be thereafter superseded by such further orders that the learned trial court would be basing on applications filed in the matter by the petitioner. So everything taken care of?
Obliged.
It is. With the above observations and the dismissal case comment.
item number 16 to 30.
Yes, madam.
Please, Your Lordship.
No, this was
It's a very peculiar case, Lordship. It's a very peculiar case. The
Coercive action, now the deputy commissioner is with a application for vacation.
yes, but they have already started.
Started the work.
Yes, they've already started, and contempt has also been filed. But Lordship, even if that application is filed, we had decided that the matter should be heard
Okay.
finally.
Who has filed that application? You have filed.
No, ma'am.
Yes, fine.
Deputy Commissioner.
Deputy Commissioners. Forget that. Have the whole matter resolved.
Yes, that's
Who is
what.
appearing for the BRO authorities here? Mr. Kato.
In the grievance is mainly against the deputy commissioner.
Otherwise, my lord, I'm appearing for respondent number 2 and 3, my lord.
Hmm.
My affidavit is ready. In fact, it has to be signed by the competent
We are
officer only, my lord.
not taking it up. Yes, Mr. Kato. There is no point in keeping this pending. Contempt will finally hear the matter.
Right.
So she will also have a very limited time now because she says the works have started. So she should know her rights. She gets it or she does not get it. That's all. As agreed to, shall
Lordship,
we close this IA or we'll keep it alive along with that?
Lordship, if my learned friends do not object, if the matter can be heard now.
His affidavit is not on record.
Lordship, although it's, I mean, the government has filed a affidavit long time back, February 2023, more than a year back.
Land.
The deputy commissioner, I mean. Lordship, the
Deputy Commissioner has also not filed an affidavit here. He has only filed a vacating.
No, he's filed affidavit
affidavit.
in all the cases.
Okay.
And Lordship, the grievance is mainly against the deputy commissioner only.
But the money will come from Mr. Kato only.
Yes.
If my lord is hearing the matter, my lord may kindly observe that the affidavit for the respondent number 2 and 3 is although ready, but the action impugned is the action by the deputy commissioner. So
Why should I make all those? If you want to do it, what is the help? We'll have it after 10 days, no problem. But tell me, what do I do with this IA? You want to press it or you want to hear it?
It may be taken up today now.
Today?
Yes.
I'm not inclined. I'm inclined to go for the main hearing.
That's what we had also decided actually.
And see, it's just an action, not to take any coercive measures.
Yes.
How is it preventing you from proceeding with the matter in accordance with law? You can't only take coercive steps against. That's the only direction. I don't understand how that is preventing your actions. वो अपलोड हो गया ना?
Since
Your grievance is basically that after the notification also some constructions have come in, which you say we will not. And their case is that the notification was issued 1 year back.
1 year, 4 months to be
4 months
exact.
back. Okay, fine.
The only issue is that only.
In that case, your lordship may fix a very short date. We are also in agreement.
Okay.
On
We'll-
31st, lordship.
We'll close this IA. We'll say that the writ petitions would now be taken up for final consideration.
Okay.
IA में लिखे ISC 20280 as agreed to by the learned counsel for the parties. The present interlocutory application as filed by the jurisdictional deputy commissioner trying for vacation of the interim directions passed by this court while order dated 24/1/2023, shall be closed inasmuch as the parties have agreed that the connected writ petitions be taken up for final disposal. Also, accordingly, the interlocutory application stands closed. Oh, sorry. कितना to है? 3 to 8 क्या?
4.
4, no. 1, 2, 3, 4. 4 writ petitions, 17 to 20. As agreed to by the learned counsel for the parties, raised it to list this matter again on 28/20.
Lordship, can it be next week, 31st?
31st.
Yes.
Okay, done. On 31, have it on 30th Tuesday,
Oblige.
30/8/2020. On which date an endeavor would be made to dispose of the petition. Full stop. Mr. You're for the land.
Yes, ma'am.
Mr. Kamduk, Learned Standing Counsel, appearing for the Land Management Department shall file his affidavit in the matter invariably on or before 26/7. 26, it's ready.
It is ready, my lord.
File it.
I have called my officer on Friday, my lord.
Friday, file it
Yes, ma'am.
on 27. On 26/7/2020, right?
Tuesday, Lordship, 30?
30 is Tuesday.
Yes, oblige.
Done?
Yes.
Leak down.
Oh, interim only.
Interim orders passed earlier to continue until further orders.
Oblige.
May I please vote? Okay, I'm for the petitioner. With this petition, I may be kindly allowed to withdraw. I've taken a consent because I have filed one title suit before the learned civil judge. Senior Division Fellow.
Last time we had indicated that only.
Yes, Lordship.
Heard the learned counsel, counsel for the petitioner, and also heard Mr. Tapin, learned counsel appearing for the so-and-so, and Mr. So-and-so appearing for, you are appearing for?
Private respondent number 4 to 8, Lordship.
Private respondent number 4 to 8. Mr. So-and-so, learned counsel for the petitioner submits that the petitioner has already instituted a civil title suit before the
Civil judge, senior division.
before the
Fellow.
civil judge,
Senior division.
senior
Fellow.
division alone, and accordingly he prays that he be permitted to withdraw the present proceedings. Prayer accepted, writ petition stands dismissed on withdrawal.
All right.
Deeply obliged.
Item number 22.
What is this? Once the director says there is encroachment,
Yes,
then he
Lordship.
comes up and says there is no encroachment.
In many cases, he have done that, Lordship, this director housing has. Not only in this matter.
We'll not go by that. We'll only go by the findings that there is an encroachment. You have encroached.
Yes.
Then if you have encroached, the action that has been taken is correct.
After site verification,
They have
there are
done it.
no such encroachment has been done.
No, that is by a housing director. Then how
Yes.
did he says that initially there was?
The housing direction is the person, this is the office who made a complaint before the deputy complaint
Mr.
against me.
Counsel, there is a written statement of yours here, your handwriting, you have written that you have encroached and you will demolish if required in
If
future.
proceeding was conducted in estate officer, during the proceeding, I admitted if I encroached, then I'm ready to remove.
Okay.
But after site verification, there are no such
Okay,
encroachment.
okay, right. But we'll say if there is encroachment on the quarter number so-and-so, land of the quarter number so-and-so, the respondent authorities will remove that. And you have agreed to that. That'll do. Okay. You do it. Shall I pass that order?
Yes, Lordship, because this
But
is,
the Mr. So-and-so learned counsel for the petitioner also heard Ms. Ete, learned. Deputy Commissioner is the state nowadays.
Yes.
It's a state.
Yes, appellate authority.
No, is it a state? Or it's an authority of the state? You have not even made the state a party. Why that this was not objected to?
Lordship,
It's Deputy Commissioner Capital. Hmm?
The last time also I had an objection, so many cases will not be filed. For a particular department, they will be,
That cannot be.
That cannot be. Once state it's.
Yes.
It's a state which has to be done. Council, next time, don't make this mistake.
I should admit.
But Mr. So-and-so, learned counsel for the petitioner, and also Ms. Ete, learned counsel appearing for the respondents. I'm not going into that in this case. The present proceedings have been instituted by the petitioner hearing, assailing an order dated Annexure 4. Dated 15/11/2023 passed by the Deputy Commissioner in a appeal proceedings so instituted by the petitioner against an order dated 3/7/2023 passed by the estate officer. Also, the appellate authority, while the order dated 15/11/2023 so passed under the provisions of Section 12 of the Arunachal Pradesh Public Premises bracket Eviction of Unauthorized Occupants bracket over Act 2003 had our whole held that the petitioner herein had illegally encroached upon and made constructions over the plot of land wherein government quarter number 40 and 41 oblique T-Roman 3 stands at 8th sector Itanagar, and accordingly direction was issued to remove such illegal and unauthorized construction from the plot of where in the said government quarter stands. Also, today, when the matter was taken up for consideration, the learned counsel for the petitioner has submitted that he has not encroached upon the land of the said land whereon the said quarter is so standing, and in the event there is any encroachment so made by the petitioner herein, the respondent authorities are at liberty to demolish the same. Also, in view of the said categorical statement made herein, this writ petition is the categorical statement made in the Deputy Commissioner. Deputy Commissioner?
Estate officer.
The estate officer, the jurisdictional estate officer. It would be Itanagar Capital Complex, Itanagar, shall, in terms of the undertaking given by the petitioner herein above, proceed to verify as to whether the petitioner has actually occupied any portion of the land wherein the government quarter number 40 and 41 oblique T-3 stands at 8th sector Itanagar. And if it is found that there is any such encroachment and unauthorized structures have been created over such post by the petitioner, the estate officer shall, without any further ado or without any further requirement of issuance of any notice, proceed to demolish such structures. Full stop. The above exercise shall be carried out within a period of 15 days from today. Within a period of 15 days, 30 days.
30 days.
My
30
lord,
days from
my
today.
lord, here application here well passing the order appeal by Deputy Commissioner. Well passing the order, emptying order, the complainant, Director Housing, submit the
Mr. Counsel,
application.
your case is that you don't have any structure over the plot of land wherein those two government quarters are standing.
My lord, structure is of course there, but it is not annexed to the quarter. Quarter number
I am not on
1441.
that. It is if that it is standing on the government land, which is of that quarter, it will go. And you have the undertaking before the appellate authority, undertaking before this court. It will go. Right? With the above observations and direction, the writ petition stands disposed of. If the estate officer finds that the land, the quarter cannot stand on air, it has to stand on some land. If that land you are encroached upon, that they will demolish to that extent. If not, because that is your undertaking. Not only before the authorities, before me today.
Done. Marvelous.
May I please, Your Lordship? We have filed our IA this morning only, Your Lordship.
It's here on record. No, it's not that.
We have filed this morning only, Your Worship.
Oh, then how will it, you have not even called for it. The Miss Sangeeta. Your name?
P. Sangeeta.
P. Sangeeta, learned government advocate. Appearing for the respondents have submitted that an interlocutory application has been filed on behalf of the respondents, praying for withdrawal of the affidavit filed in this matter. However, they said IA has not been listed today. Accordingly, the registry is directed to trace and tag the said IA along with the records of this court and list the same again on
Tomorrow, my lord. My lord, it has been already, they are just playing the delay technique since 2 years.
Maybe.
Please, my lord, tomorrow.
31. Tomorrow we have a lot of matters. 31, 31st.
Right.
They have now things are moving.
My lord. Everything taken, then they already taken adjournment.
Excellent repetition.
Taken just for filing affidavit. Affidavit. And thereafter, after filing in the month of May, they are insisting to redo it again. It's the most unique case that I have ever made.
See, sometimes a
2000
colleague of yours, a colleague of yours can make a mistake. Can make a mistake, and this is a mistake of hers. She made a mistake. Why should we penalize her? We'll permit her to rectify that. That's all.
They are getting the benefit of government appearance, and I'm just
Stay-
moving.
Your Worship,
Investing
stay
my
order.
time and energy for more than 20 times.
Stay order is in his favor.
Stay is not the main concept. No. Justification
Okay,
is the main.
what is your grievance? Let us hear them. We'll forget your affidavit. We'll hear them. What is your grievance? What do you say?
Your Worship, Your Worship, the affidavit has to be corrected, Your Worship, otherwise.
Okay, my lord. If my lord says, then.
Ligana, proceed.
Alright.
Item number 37.
There was the office note dated 23/7/2024. Service of on respondent number 3 and 8. Respondents number 3 and 8 are still not complete. It is seen that the notices upon the said respondents were issued on 18/12/2023. Accordingly, the petitioner, accordingly, the petitioner is directed to take fresh steps for service of notice upon respondents number 7, 3, 7, and 8. Okay.
Okay.
None has appeared for the petitioner on call. Mr. Katuk, learned counsel, has done a DYSGI appears for the respondent number
1 month.
1. Full stop. It is seen that on the last date of hearing, that is on 34/2024 also, there was no appearance on behalf of the petitioners, and this court had had not extended the interim orders as was passed in the present proceedings on 21/2/2024. So the above position reflects that the petitioners are not interested to further pursue the present proceedings, and accordingly, for present proceeding, in view of the above position, present petition stands dismissed for non-prosecution. Yes, Counsel.
My lord, the one prayer was missed out. The earlier interim order may be continued.
आगे वाला उनका केस में interim order passed any shall stand continued until further orders. You need not continue it further until further orders.
29.
Yes.
Your Honor, I'm appearing for the respondent number 4 and 5, Deputy Commissioner. And I have received an instruction that the award will be given to them within a week since he is out of the town for some health issues.
Give me a date.
Uh, by August 5.
Your Lordship, updated award, updated award.
Well, I don't know. Award.
Award is award.
Award is award. What is
Award
updated? Heard Mr. So-and-so, learned counsel for the petitioner. Anything, Mr. Rao?
Yes, my lord. Not only that, my lord. Giving a copy to the petitioner, that will not suffice because as per section 35, there has to be a publication. my
That's
lord.
what I'm going
Yes,
to
my
say.
lord.
That is what I'm going to say. Heard the learned counsel for the so-and-so for the learned counsel for the petitioner. Also heard Mr. Navam, you are appearing for? Respond number 1.
One chief secretary, I think my brother is appearing for DC. I don't know, my lord.
My lord, it will be there. I mean, engaged counsel.
Okay. For respond number 1. If he is appearing for the chief secretary, is additional, he'll appear for all.
My lord, anytime.
Of so-and-so. And Mr. appears for Navam, appears for respond number 1, as well as for respondent number 4, assisted by Mr.
T. Sunil.
T. Sunil, learned counsel, appearing for the respond number 4. Full stop. And also Mr. B. Pincha, learned counsel, appearing for the respond number 6. Mr. T. Sunil, on instructions from the respond number 4, has submitted that the copy of the award involved would be furnished to the petitioner hearing on or hearing on 7/8/2024 on the petitioner approaching this authority. Also, Mr. Nama has fairly submitted. Mr. Nama, Additional Advocate General, Arunachal Pradesh, has fairly submitted that the furnishing of the copy of the award to the petitioner would not suffice. The award is also required to be published in a manner as provided for under the provisions of the Madam Pura 2013 Act, 2013 Act. Act. Accordingly, the Deputy Commissioner shall also take the requisite steps in the above direction with the above. The petitioner hearing is directed to approach the jurisdictional Deputy Commissioner on 7/8/2024 for being furnished with a copy of the award, and the Deputy Commissioner shall also inform the petitioner about the manner in which this award was so
If I may,
published.
Lordship. Lordship, I have made a specific prayer in my prayer number 1A. Award and final bills.
Award and
Final bill. Bills.
Bills, no, man. Award is suffice, my lord.
Award is.
Highly
with the above observation and direction, repetition stands disposal.
Deputy. Lordship, we are sorry for interruption. Lordship, in item number 21, a small correction in withdrawal matter, Lordship.
I have wrongly informed this honorable for that what title suit is lying before the civil judge. That civil title suit has been withdrawn. Now my client has been informed. That title suit has been informed that title suit is pending before law, but that may be kindly not reflected. That's number submission.
order तुमने लिया था ना?
Item
number
21.
Item 21, Lordship.
21. लिखिए उसको काटो. Heard the learned counsel for the petitioner, नाम लेना. And also heard the learned counsel appearing for the, you are for the private respondent.
Yes, Lordship, 4 to 8.
So the learned counsel for the petitioner submits that he be permitted to withdraw the present proceedings with liberty to approach the civil court of competent jurisdiction. So the prayer is not objected to by the learned counsel for the petitioners, for the respondents. So accordingly, the writ petition stands disposed of, stands dismissed on withdrawal with liberty to the petitioner as prayed for.
Okay,
Deeply out.
Item number 40.
Who is for the petitioner?
I am for the petition.
Yes, what is
My
left
lord,
here? What is your locus?
yes, that's why, my lord, I'm seeking for withdrawal of my this case.
But I think we should impose a cost here. Waste of the court's time.
Earlier, my lord, here.
You are not even remotely concerned.
Yes,
We will not impose cost on you because your move has led to government passing an order revoking all those illegal appointments. So we are not passing any order, interim order, imposing any cost on you. Okay? Because government has passed an order. Right?
That is, for passing that such order, this honorable court has no such issue, any direction for doing so.
But they
That
have
is a
done it
part
on their
of their part.
No, they have done because you pointed out they have done. So for that, we will not question your locus and wasting the time of this court. We'll permit you to withdraw because you have done a public good. Okay. Otherwise, we would have gone in. Heard Mr. So-and-so learned counsel for the petitioner and also heard Mr. Tapin, learned counsel appearing for the sabka naam le lijiyega. Just write it down. Piece of paper. Respondent, just write it down in a piece of paper. And just write it down. So-and-so. Mr. So-and-so learned counsel for the petitioner submits on instructions that the petitioner be permitted to withdraw the present writ petition. Full stop. The learned counsel for the respondents does not object to such prayer. Full stop. Accordingly, the present writ petition stands dismissed on withdrawal. And when you draft your petition, your intention should not come out. You wanted to file a writ PIL, but you filed a writ petition, but your whole writ petition is PIL.
Item number 41.
My lord, I'm very sorry that I could not produce the document which is sought by this honorable court.
On the prayer of Mr. G. Tarak, further 10 days time is, further 2 weeks time is granted.
My lord, the officer, they're telling they could not trace the document.
Then,
That is my lord,
then how have you arrived at that satisfaction?
Then 10 days maybe let them try their.
Next, others, I'll hold them here. They'll have to, because you have dealt with somebody's rights.
The problem is the officer who
Now,
passed
Mr.
this order is already retired.
His services are unsatisfactory, that is one aspect.
Yes.
Second aspect, he is not complying with the requirements of the order of appointment.
Yes.
That would be a different aspect. You have missed up both and you have passed that order. We want that. I want that file.
That man had already retired.
How sitting in Itanagar, that man has drawn this
Yes.
conclusion with regard to her service. You are continuing in your services?
Yes, ma'am. Yes.
Then you continue. But Mr. Tarak, learned counsel for the petitioner submits that he be granted further 10 days time to place on record the to furnish the file from which the order dated 20/10/2020, Annexure F, page 27 to the writ petition was so issued. Full stop. Registry to list this matter again on Seven, 8/2024.
Obvious.
Most of it. Item number 42 and 43.
Solatium.
Solution and land compensation, my lord. They
Now,
have,
show me the parcel of land that was taken from you.
my lord, they have given the print area, my lord.
They have said that only there was a construction of your house which
Yes.
they have broken, and for that they have given you 23 lakhs.
Yes, my lord.
Now, if there is no land involved, Solatium would not come in.
My lord, in WPC, WPC number 309, my lord. It will apply, my lord. But, my lord, my lord, just now your lordship has said, my lord.
No, that land may be community land or somebody else's
No,
land.
it was my
It
private
may be
land.
even government land.
It was my private land.
Show me the LPC.
LPC, in village, there is no LPC, my lord.
Then how can we, today, this is something which took place in 2012.
But they have paid me the
Then there
compensation.
is a direction. There was a review made.
My lord.
And in terms of that review, this order has been passed.
Yes, my
Now
lord.
show me that what portion of your land Because they have not paid you anything for the land.
Yes, my lord.
Why?
That is the question, my lord.
Why? That is for
Because-
you to answer.
My lord, in WPC number 309, item number, last item, my lord. In the last item, first we have filed this writ petition, my lord. In this writ petition, my lord, there was a first round of litigation, my lord.
That division, the
Yes.
whole villagers had come down.
No, my lord, that WPC 107, my lord, page 57, my lord. The
57,
representation was
that
directed to this
representation
court.
was directed.
Yes, my lord.
My Lord Justice Sarato's order.
Yes, my lord. Now their interpretation, my lord, page 63, my lord.
That's the order.
Yes.
That is under challenge here also.
Yes, ma'am. Yes, ma'am. Yes. They say, ma'am, nil amount was paid as
Was
a,
estimated for, read the whole thing.
Yes.
Or the property of the appellant, other inspect so and 30% lump sum was applicable only for the land value as per LA Act. Right? Please
yes,
read.
my lord. Ram Mehra, my lord, this case in my lord, this.
Now show
Ram
me
Meher,
from
Mal-
here, what is the portion of land that they have acquired from you? And what is that land? Where is that land? Which is that land?
My lord, page 35, my lord. Of,
Because you have brought on record certain lists,
yes, my lord.
right?
Yes, my lord.
In that list, where is your name?
Yes, my lord.
Page
down-
65.
Yeah, page 35, my lord. Page 35, my lord. This is the first evolution. Writ petition 231, my lord. Yes,
231 years.
yes, my lord.
Page 35.
35, my lord. Serial number 7, my lord. I am here, my lord.
Sonam Gairu.
Yes, sir. Yes, my lord.
SPT brick.
Yes, my lord.
And this is something which was done at that point of time.
Yes, my lord.
Then we don't think so. You have made out a case.
My lord, what I am saying, my lord,
Mr. Counsel, to come to that conclusion
my lord.
by me,
Yes,
I can't arrive at that conclusion in air.
Yes, my lord.
You will have to show me what land has been taken.
My lord.
Because it is not impossible that a person can be compensated for the crops, for the house, but not compensated for the
Land.
land because that land is government land.
Yes. No, no, my lord. That land is not a government land. No, everyone was paid. My lord, some of the beneficiaries, they were paid 100% solution, my lord. For the value of land, my lord.
I am ready to pay you.
My lord.
I am ready to pay,
My lord.
but direct for your payment. But show me which is the land.
Land, my lord, they have estimated, my lord, from this area, my lord, 169, my lord, 164.90 square meter, my lord.
Where?
Plint area, my lord, page 35, serial number 7, my lord, Sonam Gyatso, so and so, plint area, my lord.
That is the house.
Yes, my lord.
Then
Now, my
show
lord,
me you are also a master of that land. 23 lakhs for this house there.
in villages, my lord,
I can't help it.
well, a week time may be given so that I will
No.
try to.
Sorry.
My lord, in that case, my lord, I may be hurt, my lord.
Yeah, I'm hearing you. I'm here till 4:45. No problem.
My lord, I am the
Yeah.
last item, my lord.
But only show me where is your land. That much. only.
Well, in the Dirang village, my
Because
lord.
this court has a very bad problem. Something goes in.
My
Until and unless you don't take it out,
My-
it remains stuck.
My lord. No, they,
Yes, Mr. Tapik.
they have not disputed that the land does not belong to me, my lord.
If so for that aspect is it's not clear also. This, whether that was a government lane or private lane.
Because without that land,
No,
he is not entitled to solicitum and he is only clear his solicitum.
that is a no.
And he has made a prayer that he should also be compensated for the land.
Land.
But from 12, he had not made any endeavor to that effect.
And
My lord, no one was
and
paid, my
this
lord.
issue has been raised for the first time in on 4/10/2018 laws.
18,
Whereas
huh?
compensation was received in the year 2012 laws.
That I would like to clarify, my lord. Now, what happened, my lord, 2012, I was paid compensation, my lord. I was unaware, my lord. I don't know the knowledge of technicalities of law, my lord, compensation, my lord. Now, in 2017, there was a notification by the state government saying that the compensation would be paid under LAR Act 2013, my lord. Now, coming to that, my lord,
You
the-
will
some
not
of the
be
ben-
entitled because you have already received
Yes, my
that
lord.
in 2012.
Now, after that event, my lord, some of the beneficiaries were paid 100% solution. Knowing that, I have submitted a representation, my lord.
Who are those? Who are those?
Yes, my lord. They are, my lord, may please come to page 57, my lord.
57.
Yes, my lord. This is the second evolution, my lord.
Hmm.
I am at serial number
And
9.
now,
I am in serial number 9, my lord. Serial number 9, I am there. Now, serial number 10, my lord. C. Sewang Dorji, my lord.
serial
Sewang
number-
Dorji. Serial number 10, my lord.
Ah,
Sewang Dorji. He has been paid, my lord. My lord, may please come to page 100 or page 165, my lord. 65, my lord.
Which is
serial
the
number, yes, my lord.
serial number?
1, my lord. He is the serial number 10 in, my lord, this valuation. And here, my lord, serial number, my lord, 1, my lord. He has been paid, my lord, compensation of, my lord, after 100% solution, my lord. The value of the land has been assessed, my lord. Everything has been done by the authorities, my lord. Not in my case, my lord.
Where is that soliciting?
My lord, serial number 1, my lord, location so and so, Chinese, my lord, is here. Type of building so and so, print area, rate 900 unit square meter, my lord. Market value so and so, my lord.
Yes, Mr. Tapin, what do you say about this?
Okay, serial number 10 lawsuit.
No, page 65, serial number 1. That serial number 10 is only for the house,
Oh.
right? Serial number, page 65, serial number 1, again.
Page 65 lawsuit.
And the serial number 2 is in serial number 13, my lord. There are so many people from here.
Lawsuit, what I understood from this case, lawsuit. Here lawsuit for this particular estate is a long estate. In compensation lawsuit, it was paid even after 2013, in 2017 also. And Solatium was, it seems, was paid to those beneficiaries also who had not received lawsuit before 2013 also. In 2017, those lawsuits, some of them have been paid lawsuit. In their cases, lawsuit from whom lawsuit, land has also has been expelled lawsuit, just since Solatium has paid.
Now,
But
tell me one thing,
but
Mr.
petitioner's case lawsuit.
Mr. Tapin, just clarify one thing. Can Solatium be paid for crops standing without the money given for the land, or the house standing, or Solatium is only in respect of the land value?
Correctly.
Land value?
Yes.
Now you come to page 65. This is an estimate of the buildings, right? And Solatium 100%, that is under the 2013 Act that has been given. Because to 1894, it was 30%,
Yes,
15% and 30%.
Yes.
Your deputy commissioner has not looked into the matter in the manner required.
Even here in this case, CBI, some anomalies was there also. The case was raised, CBI, some documents even have been seized by the CBI also.
So what do we do is, we will interfere with this Annexure 9. Remand back the matter to the deputy commissioner. Require him to take into account this estimations made in respect of others. He will make a fresh representation, and then you pass a fresh order.
Yeah, also, what is not submission? We know this court of law. If something wrong has been done in deviation from the law, suppose a Solatium has been paid in respect of crops, for example, that's not the say of the law. Can we impose that? That's someone by submission law. If that is wrong, to them wrong.
Pertinent submission. Yes. Now, if something has been done in violation of the law,
my lord,
can we direct that to be perpetuated?
My lord, what I say, my lord, that may be the another factor, my lord, because this 2013, yes, my lord has rightly said 1894 only Solatium on the value of land only, market value of land, my lord. This, my lord, they have paid, this what I am showing, my lord, they have been paid, this other beneficiaries has been paid 100% Solatium, and after that I came to know about my rights, my lord. So why I filed a representation, my lord, on 4/10/2018, my lord. And basing on that, this honorable court has passed a judgment, my lord, directing the respondent authorities to dispose of my representation, my lord. Now, my lord, this structure, my lord, cannot be in the air, my lord. Now, my lord, even my lord may kindly see, my lord.
Okay.
Of the
what
affidavit.
we do is, we will remand back the matter to the authorities. It will be under the 1894 Act itself.
Yes, my lord.
But they will now also
ascertain that
address
my land.
your submission with regard to the land.
Yes, my lord.
Right?
Yes, my lord.
That
Whether
much
it was a government land or
What
private
was it?
land, what
Yes.
is the status of land, why lawsuit compensation was not paid?
Will not.
Yes.
But Mr. B. Pincha, Learned. But Mr. B. Pincha, learned counsel for the petitioners, though a writ petition, through 31 AP, 309 AP. Also heard Mr. S. Tapin, learned counsel appearing for the, learned senior government advocate appearing for the state respondents. The petitioners, by instituting the above writ petitions, has assailed a communication dated, order dated 24/9/2020 passed by the
Deputy Commissioner, my lord, West Criminal District.
has assailed the observations of the committee as constituted by the Deputy Commissioner West Cumming District in pursuance to directions passed by this court wide order dated 29/5/2020 in writ appeal in writ petition number 107/2020 regard 2020. So the petitioner has also
Annexure 10, my lord.
assailed a communication dated 30/9/2020 passed by the Deputy Commissioner in pursuance to the observations made by the said committee. Also, the petitioners have also in WPC number 231 AP 2022 prayed for a direction upon the respondent authorities for assessment of the value of the land of the petitioner purportedly acquired by the respondent authorities along with payment of Solatium therein in terms of the provisions of the Land Acquisition Act 1894.
Yes, ma'am.
There is a 30%.
On the push up. The petitioner being aggrieved by the manner in which the compensation was so determined in her case, had approached this court by way of a writ petition by way of instituting a writ petition being WPC number 107 bracketed AP/2020. This court, wide order dated 29/5/2020 on considering the issues so arising, was pleased to dispose of the same with a direction to the respondent, to the jurisdictional deputy commissioner to consider and dispose of the representation dated 4/10/2018 as submitted by the petitioner hearing. Also, on receipt of the said directions, on receipt of the said directions of this court, the deputy commissioner constituted a committee for examining the grievance of the petitioner pertaining to being authorized Solatium against compensation for his house in BCT Double Lane Road. Also, the said committee on considering the said issues wide its report dated 24/9/2020 proceeded to hold that the petitioner's house having only been demolished and no land being taken acquired from the petitioner and Solatium being only applicable for the land value involved under the provisions of the Land Acquisition Act 1894, the claim of the petitioner for being authorized 30% Solatium on the land value would not be called for. So, the Deputy Commissioner, West Cumming District, in terms of provide order dated 30/9/2020, endorsing the report of the said committee, proceeded to hold that proceeded to accept the said findings and disposed of the claim of the petitioner herein. Also, the learned counsel for the petitioner has submitted that the respondent authorities, while disposing of the representation in the matter, a representation of the petitioner in the matter had not touched upon the issue as to whether any land of the petitioner was so acquired.
And the area of, and the area of land
Was acquired or not. Full stop. Mr. Tapin Lanet, Senior Government Advocate, submits that the petitioner's land in the present proceedings has not been acquired, and it is only the compensation having only been paid for the demolition of her house. It is clear that the petitioner, the land over which the said house of the petitioner stood, did not belong to her. Full stop. In view of the above position, in view of the above position, this court is of the considered view that the Deputy Commissioner is required to bring on record a categorical finding to the effect as to whether any land of the petitioner was so acquired. So, it is only in the event the land is so acquired that the petitioner would be entitled to the Solatium of 30% as provided for in the provisions of the Land Acquisition Act 1894. Also, in view of the above position, the writ petition stands disposed of, requiring the disposed of without interfering with the report of the committee dated 24/9/2020, as well as the order dated 30/9/2020, requiring the petitioner, the jurisdictional deputy commissioner, to carry out and to determine as to whether any land of the petitioner was so acquired and or only the house of her was demolished, for which she was duly compensated. So, basing on the conclusion that would be now arrived at, would now be reached by the Deputy Commissioner, further proceedings in the matter be initiated. So, if it is found that the land of the petitioner was actually acquired,
yes,
the petitioner would be entitled to Solatium
from the date of
Solatium in the manner as provided for in the Land Acquisition Act 1894. Full stop.
And any other benefits from it?
No, that much only. So and so. Full stop. The Deputy Commissioner, while proceeding to determine the said question, shall also provide an opportunity to the petitioner hearing to establish her right in the matter.
In next case, they ask for land compensation.
We are not going for that.
The second case.
We are not going for that. We will only limit it to this.
No, that is.
We are only limiting it to this. Full stop. Okay.
My lord, actually, my lord, I have been deprived of the land compensation due to the fault of the respondent, my lord. If, my lord, so, my lord, my right should be, my lord.
I'll
yes.
We will say inquire if there is land has been taken and the same has not been compensated, requires compensation under the Act of 1894 as on that day, along with Solatium be received.
And other benefits, my lord.
Nothing. Dispose of. मैं थोड़ा last वाला थोड़ा सा correct कर दूंगा, एक copy दे दीजिए. एक draft कर.
It be a common order.
Common order. So, दोनों writ petition में common order. With the above observations and directions, both the above noted writ petition, both the writ petitions number लिख दीजिएगा. Stands disposed.
In one, they ask for solution, in other for land compensation.
Yes.
Anyway.
Because see, there is a gap there.
Yes.
Because whether his land has been acquired or not, you have not given.
Yes.
Whereas in others similarly situated, maybe an illegality. Say that's an illegality, we will not repeat it. Enough. He's out. That much only you have. Anything more?
And explanation. Today I was by a natural call. I could not attend in.
What is it, Mr.? Item number?
Small order.
क्या था क्या order पास किया? 3 weeks. File भेजा था हमको मालूम पड़ेगा.
So madam, let it be on Friday, madam.
What is the issue?
Madam, regarding madam, the payment of the compensation, madam. Already, madam, the compensation for making payment was already directed by this honor court. And in spite of that, madam, the section 30 of the Lara Act, which has not been complied by the authorities. That is 100% Solatium and 12% interest, madam.
It was under the Balipara Act.
Balipara Act.
No, Balipara Act has been amended. I saw in the papers the
Yes,
other day.
yes,
Some
yes,
amendment has
yes.
been. What is the nature of that amendment? Has been amended by the recent in your legislature. Yesterday, 2-3 days back.
Sorry, I have not gone through.
Oh. Well, this is a order passed by the Supreme Court.
For amendment.
It has been tabled for.
Assam Frontier regulation has been amended. That's okay, but so for
No, just I saw the rest, but I could not go through it.
My lord, this order covers everything, my lord, as per the Lara Act. My lord. But whereas the responsible authorities did fail to
ये कितना
act
कितना
upon
कितना time
the
दिया इसमें? हाँ? कितना time दिया इसमें? 3 weeks दे. 2 weeks कर दीजिए. 2 weeks.
1 week, my lord. 1 week.
Okay. 1 week. Mr. Son says we can't say no. 1 week.
I'm
After a week.
highly obliged.
कौन है? बोल दीजिएगा. 3 weeks है 1 week.
Very nice.
Finished.